We now turn to the fourth case on this morning's docket. That is case number 104206, State of Kansas v. Edward Speer III.
Good morning, Your Honors. May it please the Court. Lydia Krebs of the Capital Appellate Defender Office for the appellant, Mr. Spears. And if I may, Your Honor, I would like to reserve 3 minutes for rebuttal, please.
3 minutes would be granted.
Thank you, Your Honor.
Opposing counsel, are you ready? All right, thank you.
I'm terribly sorry.
There was some delay. He's fine.
I apologize. Unless the Court would prefer otherwise, I would like to submit issues 3 and 4 on the brief and instead focus on issues 1 and 2, which, if I may, I would like to address in reverse order. In issue 2, Mr. Speer argues that the court must reverse 4 of his 6 convictions because LS repeatedly admitted that she was only guessing when she said that Mr. Speer touched her 11 times. In its brief, the state argues that Mr. Speer, quote, somehow reasons that 4 of the defendant's 6 convictions should be reversed based on this perceived lack of evidence. It appears the state may be confused as to how I reached that number, and I apologize for any confusion if that wasn't clear. I just want to briefly explain my rationale on that point. LS did testify that Mr. Speer touched her more than once. Therefore, there was sufficient evidence to allow a rational fact finder to find him guilty of 2 counts of aggravated indecent liberties with a child. But a rational fact finder could not convict him of any more than 2 counts of ag indecent liberties because the only evidence that Mr. Speer touched her more than 2 times was her guess that it had happened 11 times. So the evidence supports 2 convictions. The district court entered 6 convictions. 6 minus 2 is 4. That's how I arrived at the figure of requiring the reversal of 4 of his convictions for aggravated indecent liberties. Unless there are any questions on that issue, I would then move on to...
There were 10 counts, right?
There were originally, I believe, 10, and the jury convicted on 6. But there was only sufficient evidence of 2.
And the testimony was it happened about 11 times.
She said like 11 times, yes. At the prelim, she said like 10 times, but she admitted both were guesses. Both the 10 and the 11 were merely guesses. Unless there are further questions on that issue, I would move on to the 6455 issue. And, Your Honors, I have prepared remarks on this, but I know the court has heard the bulk of them already today. I would defer to the court as to whether the court would prefer that I just stand for questions or if the court would prefer that I go through those arguments.
Counsel, why don't you start and we'll see how far we get.
Of course, Your Honor. So there are basically 2 parts to my argument. First, although the legislature may well have intended to amend KSA 6455 to make propensity evidence admissible, to make prior bad acts evidence admissible to prove propensity, that may well have been the legislature's intent. That is not what the legislature succeeded in doing, and that's true for 2 reasons. First, the legislature included no language anywhere in the statute that exempts 6455D from the rule included in 6455A, which explicitly states that evidence is inadmissible to prove propensity. And I think it's especially telling that not only has the legislature demonstrated the ability to do this in other statutes, such as the one that I cited in my brief, but we can see that it has this ability from the very statute in question. And specifically, I'm looking at subsection C of the statute, which has this prefatory language that says, in any criminal action other than a criminal action in which the defendant is accused of a sex offense. Had the legislature knows how to exclude sex crimes from a part of the statute. It could have simply attached that language as prefatory language to subsection A, and then A would clearly not apply to sex crimes. Similarly, it could have just added a subsection that says, notwithstanding subsection A, evidence of prior bad acts or prior crimes is admissible to prove propensity when a defendant is charged with a sex crime.
Well, I'm sorry to interrupt, but I guess I would like for you to address whether you think this is ambiguous, because I understand that perhaps the legislature didn't use the clearest language they could have, and that we can come up with ways to make it clear, but you seem to agree that we all know what their intent was. Do you also agree that it's certainly ambiguous, to say the least, and if it's ambiguous, we look to their intent?
I think that subsection A is absolutely unambiguous.
Right. I'm talking about the total now.
Reading it as a whole, it may be ambiguous, and we do look to intent, but we look to intent as expressed through the language, and the other rules of statutory interpretation. And I think the inclusion of one thing or the exclusion of one thing, we can infer from that the legislature didn't include that language in subsection A. And so I think that's a plain language argument that it didn't intend to exempt subsection D from subsection A. To the extent that it is vague, I would argue that the rule of lenity applies and that this court should interpret it strictly in favor of the defendant. The second part of my argument is that prior crimes evidence is still only admissible to prove a material fact that is in dispute. So essentially the same analysis that applies under subsection B also applies to the admission of evidence under subsection D. And that's because the concept of relevancy in Kansas, as your honors have pointed out repeatedly today, includes a materiality requirement. And as I believe Justice Beyer pointed out in the last argument, this court has held that in order to be material, a fact must be at issue. So even under 6455D, evidence of prior crimes is still only admissible to prove a fact at issue. And in this case, the evidence was admitted to show intent, an absence of mistake or accident. None of those factors were at issue in this case because Mr. Spear did not assert an innocent explanation for his behavior. Intent isn't at issue similarly because if he committed these alleged acts, there's no doubt that he acted with the requisite intent. Although evidence of an innocent explanation did come in at trial, it came in during the state's case in chief. And in Prine, this court held that the state cannot open the door for itself to admit 6455 evidence in order to prove lack of mistake or evidence. The state, in its brief, seems to take issue with this rule, complaining that the evidence of his statements offering that innocent explanation were clearly relevant in the state's case in chief. And I don't dispute that. My argument is not that those statements were inadmissible. It's just that the state can't have its cake and eat it too. It can have those statements admitted, but it can't use them as a justification then to admit evidence of prior bad acts under the rationale that Mr. Spear had asserted an innocent explanation, which he didn't do in this case.
How do you respond to the argument that defense counsel mentioned in an opening statement even before the states admitted the evidence, and then also repeated that in closing statement?
Well, the state discussed it first in opening statements, and it had already been ruled admissible, and I don't think that defense should be handcuffed. If he knows that evidence is going to come in, he should be able to respond to it. He tried to have it excluded. It didn't inform his defense. That certainly wasn't the bulk of his closing argument. He did mention it briefly, but there are pages and pages in which it's clear that defense's argument here was just to characterize the victim as not credible and to argue that the state hadn't proven its case. But I think that the strongest argument there is that the state brought it up first in opening statement. Finally, the district court's error in admitting the evidence of prior crimes was anything but harmless. In fact, I would argue that it's much more harmful in this case than even in the typical child sex crimes case in which the evidence is overwhelmingly prejudicial anyway. And that's because here the jury heard evidence of more acts of which or with which Mr. Spear had essentially gotten away. There was more evidence about the prior acts than about the current acts. So the jury may well have decided to punish Mr. Spear based on these acts that he hadn't been previously punished for.
Isn't that the effect of D, is that it really does, if there are prior crimes that are, especially in child sex offense cases, if there's prior crimes, the focus will become or could become those crimes. And if they're allowed in without any kind of weighing, or it'll be he did it before, so he did it now. Well, that'll be the focus.
Yes, I think that is definitely the focus. In this case, I think that problem is exacerbated because it was so confusing. I think it's confusing for me, even going back and being able to read through all the testimony to discern which acts could support the charges in this case, especially because the state presented several witnesses who didn't even discuss the current crimes. I think we went through 3 or 4 witnesses who talked about the previous crimes before we even got to the present crimes. And these crimes happened in different cities and at different times, and the victim had a hard time remembering and admitted as much. In fact, the state brought that up in its brief, that the passage of time had obviously had an impact on her memory. So I just think in this case extremely likely that not only did the jury use this evidence as propensity evidence, but it was so confused by all of this information that there's a possibility or even a probability that it based some of the convictions on those prior crimes.
But there is some objective evidence that they sorted through because they only convicted on some and acquitted on others.
That's true, but we don't know what went on in the jury room, and that could have been a compromise verdict. There's just no way to tell what acts the jury based its decision on. It's certainly clear that the jury tried and did its best, but as I said, I think it's confusing even having the entire record in front of me and reading through it several times to discern what acts supported the charges in this case. To be honest, I'm a little confused by the state's argument in its brief. The state spends several pages talking about the history of the statute. It then spends a lot of time talking about subsection C, which I would argue doesn't apply in this case. It then argues that Mr. Spear appears to be confused about subsection B and subsection D, but I would just respectfully suggest that on pages 14 and 15 of Mr. Spear's brief, Mr. Spear has explained why the same analysis applies to subsection D as applies to subsection B. The state does make a cursory effort to explain why the evidence was relevant here to prove intent and absence of mistake, but really only by arguing that Prine was wrongly decided. And importantly, the state makes absolutely no argument that if the evidence did come in wrongly, that error was harmless. And it's the state's burden to prove that the error was not harmless. So I would argue that if this court finds that the district court did err in admitting it, it must reverse because the state has failed to meet that burden. I have a minute left, and if I may, I just wanted to speak briefly about this argument of affirming the district court as being right for the wrong reason. I think that's problematic in this case, and maybe in some of the other cases as well, because the record is simply insufficient for this court to decide that the district court reached the right result for the wrong reason. And that's because in order to determine probativeness, I think it requires a credibility determination here. I think that the allegations of the previous abuse, she was confused, she was having a hard time remembering anyway. This court's job is not to weigh the credibility of a witness, and in determining whether the evidence was probative, I think it would have to necessarily make a finding of whether that testimony was believable. Similarly, the determination of whether evidence is more prejudicial than probative is subject to an abuse of discretion standard. And I don't know how this court can review a ruling that the district court never made. I think that that's just outside the purview of review here. And finally, I would point out that the state never argued that in its brief. It hasn't attached a 609 letter citing authority that this court can do that. And similarly, had the state addressed those issues in its brief, I would have addressed, for instance, why this wasn't admissible to prove propensity. And I haven't had the opportunity to do that because the state didn't bring that up in its brief. I see that I'm out of time. I would respectfully request that the court reverse Mr. Spear's convictions.
Do we have any further questions of counsel? Thank you, counsel.
Thank you, Your Honors.
If it pleases the court, Keith Schroeder, Reno County District Attorney, 27th Judicial District. On behalf of the state of Kansas, the appellee in this matter, I was trial counsel in this case. I guess since this is the third day that the court's been recording this, I could ask for a Memorex moment, maybe just replay a lot of my argument. But I'm going to rely upon a lot of that argument with the court, with your permission, without having to repeat a lot of the things I've said. There are some things, though, that I've heard that I guess I'm going to use this opportunity to comment on. One of the issues was the issue the court's having with trying to define relevancy or materiality, and how do we decide that? What are the rules? The rules are stated in KSA 6401, subsection B, which talks about evidence, which defines relevant evidence as evidence having any tendency and reason to prove any material fact. It does not say that fact has to be in dispute. I don't believe
What does material mean?
Well, that's a good question because there's no statute on that.
No, there isn't. And
materi-
that's what I was suggesting earlier, is that perhaps, and
Material-
we've said that in issue is a facet of materiality. I mean, it doesn't do any good in a case to prove a completely unrelated crime. I think we all kind of, unrelated prior crime to show propensity, because if it's completely unrelated, if somebody passed a bad check, it's not relevant to whether they may have molested a child, right?
Yeah, and yes, that's correct. The materiality, I can assure you that if I could have found something on point for defining materiality, I would have included it. I couldn't. I kept finding materiality means the evidence is relevant, and relevant means the evidence is material. And even in the relevancy statute, it describes it as being material. It's one of these things that is going to be within the discretion of the court to determine, as it would any other evidence, as my preceding counsel indicated, whether it be a gun or a knife or some other type of evidence. Justice Johnson asked a question about, could you ever foresee in a sex-related crime where you wouldn't admit evidence of other crimes of sexual nature? Absolutely. If somebody were convicted, say, of involuntary sexual relations, the so-called Romeo and Juliet statute, where they were 18 years old and they had consensual sex with their 15-year-old girlfriend, and then several years later it's alleged they broke into a house and raped somebody or some type of sexual abuse on a child for fondling or something along that nature, the question would be, does this prior voluntary sexual relationship with a girlfriend in a dating relationship, because of age making it illegal, somehow have relevancy to what happened here? Probably not. But that's going to be up to a court to decide. There are different things that might not be relevant. There are a lot of statutes under those three different sections.
Aren't you, my question to Ms. Krebs, but aren't you, and you're in the trenches, aren't you now permitted to argue if this evidence is allowed in under propensity? It happened before, so it happened now. Isn't that argument? Isn't that a legitimate argument you can make and that you will make? Which is why allowing this evidence will be important to you, especially on a case where it's maybe a he said, she said, or vice versa.
I guess I would agree with you to some extent. I don't think it has the power with the jury you might think.
Oh, you don't?
No, I
really don't.
Think
You don't think a prior conviction for the same offense, it doesn't have any power with the jury?
Sometimes juries are more offended by you bringing that evidence in, saying you were trying to get us to find him guilty because he did this instead of the facts on this case. Yes, I think there are times that bringing in other crimes evidence is a bad idea for a prosecutor. It's not always a good thing. It's not always a good thing to stand up there, and if you're going to fool the jury by saying he did this time, he must have done it this time, it'd be like saying you got a speeding ticket 12 years ago.
That might be true on some cases, but in a sex offense case involving a child.
In a sex offense case involving a child, the same rule applies. I think juries could be very offended if they think that's the only evidence you've got. You better be able to have something to establish this case. They can then consider on the issue on the issues whether or not, and they can play that however they want. Yes, I think it comes in as propensity. I think it does, but I think it would be a foolish thing for a prosecutor to get up there and say, he did it this time, therefore he had to have done it this time. I don't think the jury's going to buy that.
Could I ask you to go back to your discussion of relevancy? I'm a little confused because the statute defines sexual misconduct, and it seems to me in defining sexual misconduct, it's already saying these are the crimes or these are the instances of sexual misconduct that we will find relevant as propensity evidence. It seems to me the relevant and probative has already, it's superfluous. It's defined within the statute because the example that in the last case that was given was the idea of an old adultery conviction. Well, an old adultery conviction wouldn't constitute sexual misconduct the way I'm reading the statute in the various sections, so you never would get to an old adultery conviction. Does that make sense? Maybe not.
I think I understand what you're saying.
He gave that as an example of when the trial court might have to decide whether that was relevant or probative. And it probably wouldn't be. But the fact is, you'd never get to that because sexual misconduct is defined and it doesn't include an old, from what I can see, it doesn't include an old 1965 adultery conviction, as an example. And maybe, I don't know yet if it includes the Romeo and Juliet example you just gave, but if it doesn't, you'd never get to that because it doesn't come within the definition of sexual misconduct.
My understanding was it's talked specifically about sex offenses under Articles 34, 35, and 36 of Chapter 21, and the Romeo and Juliet statute, voluntary sexual relations, would be under those sections. I think the difference that we're talking about here is...
So it would come in as sexual misconduct. But you're saying that would be the extra...
It wouldn't come
step.
in. It would be admissible.
Okay.
Then the judge, the trial judge, has to make a determination as to whether it's relevant and material. So that's a separate step that the trial judge does, and then the court reviews that decision based on an abuse of discretion. Was, in fact, did the court abuse the discretion? Would anybody disagree with the judge? Could they?
Would you agree, though, that the adultery conviction that was mentioned in the last argument wouldn't even come in because it wouldn't be sexual misconduct as defined in the statute?
Adultery would be... I apologize, I don't recall the statute number for adultery, but I thought it was under Chapter 34 or Article 34 of Chapter 21. I'm sorry.
Well, I'm just trying to figure out if
it falls under one of those specified under subsection D, Articles 34, 35, or 36 of Chapter 21, 34, which, by the way, those have all changed, haven't they? Yeah. But 34 was more of your sexually violent crimes against, it could be rape. 35 was the crimes against the children, which included abuse of a child. 36 family relationships or something, if I recall. If they fall within that, they're going to be admissible. That doesn't mean that they're going to be admitted. They're admissible. The court then has to decide whether they're relevant material. Now, I want to, Justice Johnson's several times asked questions about limiting instructions. We can actually see it get to the point where, none of this is in my brief, okay? I apologize to counsel, to the court, but I know that there was a line of cases, the Cathy case and the McCorkery cases, that dealt with bringing in evidence of flight and giving a limiting instruction that says you can consider the fact that the defendant attempted to break out of jail for a consciousness of guilt, but you cannot use that as the sole evidence by which you find the defendant guilty. Something like that. And McCorkery said that. Then in Cathy, they called it the McCorkery prohibition. And after that, there were several cases that had been reversed because limiting instructions were given when flight evidence was admitted. And the rationale by the court was you've just overemphasized the impact of this evidence. You're telling the jury that if, and as I recall McCorkery, there was no evidence the defendant had attempted to escape from jail, but the court gave the jury the instruction that if you find the defendant attempted to escape from jail, you can't consider that as sole evidence of guilt on rape. And then later became the McCorkery prohibition, but the court has later said it's reversible error if you give a limiting instruction. Now in this particular case, let's drawing it back into this. The victim in this case, the 6455 evidence we're talking about involves the same victim. Not a different child, involves the same victim and other sexual conduct that occurred outside of Reno County, Kansas. So the question was, well, that's other crimes. Under the old res gestae rulings, no, it wasn't. It was independent. It was admissible independent of KSA 6455, and there was to be no limiting instruction given. But after Gunby, then it was held to be, it has to come under 6455. And under 6455, we've traditionally given limiting instructions. So there can be an argument that no limiting instruction need be given. If a limiting instruction is given, for example, I believe in this case it was given on the issue of intent, absence of mistake, or identity. If it was erroneous to have given that instruction, it did nothing but benefit the defendant. It narrowed the scope by which they could consider that evidence. It narrowed it. It's not just a matter of saying you can consider it for whatever reason you want. They did it this time, they did it this time, they did it again. You've narrowed it by giving that limiting instruction. If it was an erroneous limiting instruction, I agree with my predecessor. It's clearly a harmless error. But for that instruction, the outcome is pretty obvious because it just limited it. So those are a couple of things that I guess I would point out to the court. The last issue, I concede. It appears the trial court erred when it ordered lifetime post-release supervision when it should have been lifetime parole. I would respectfully submit that is something maybe that could be corrected with a journal entry as opposed to remanding the whole case back for sentencing where we have to put family members and people on notice and they come into so that is something we do acknowledge it should be lifetime parole. It appears to be something misspoken by the judge, a misnomer. I'm not sure the misnomer rule applies to that, but we do acknowledge that. As far as the evidence about whether there was sufficient evidence on all of the charges, this jury deliberated for 2 days, for 8 or 9 hours. And during that time asked a multitude of questions, all specifically designed to determine how many times it happened. They were asking for readbacks on a physician's testimony, a readback on the parents' testimony. One time they asked a question specifically about whether a French kiss qualified as lewd touching. They were looking at the number of times that this happened. They deliberated on it within their discretion. They made that finding. We asked that there is sufficient evidence whereby a reasonable fact finder could have determined that the defendant did this 6 times.
Can you identify six times?
I'm sorry?
Can you identify 6 times?
She said it happened several times, and she identified 10 times, 11 times, somewhere up in there.
So that's all you can really rely on is her categorization of those numbers. Because this isn't, as I understand it, this record isn't like sometimes when you have different locations or we have the car and the house, but sometimes it'll be like the house we lived at during that time period and then we moved in this house, or there's nothing like that to help. I'm
not prepared to go through and tell you each time right now, but if you look at the times, the opportunities, the time of opportunity, and the times that were admitted, or that were acknowledged there had been a touch here or a touch there, or what, if you look at those, I think you can come up with 6. The jury did. They certainly didn't do it by flipping a quarter. They clearly acquitted on 4 counts. They took this very seriously. In fact, the judge, I used the judge's comments in my brief. The judge noted that specifically. This jury took this very, very seriously and determined on this or deliberated on this issue. We ask that you uphold their verdict.
Any further questions of counsel? Thank you, counsel.
Thank you.
You reserve 3 minutes.
May it please the court, I did just want to address, the state again brought up the issue of materiality and whether or not that involves a fact at issue. The state several times today has invoked the federal rules, and I would point this court to the Reed opinion at page 505, in which this court discussed Federal Rule of Evidence 401.02. Under the federal rules, in order to be relevant, evidence must be material, and one of the components of materiality under the federal rules is that a fact is in dispute, and whether the issue is in dispute is determined by substantive law. This court, after pointing that out, then says that the same merger of those elements is found in the counterpart, Kansas's KSA 6401B, saying that that, again, recognizes that in order to be material, a fact has to be at issue, and it cites cases going back to 1976. That means that the legislature has had approximately 40 years in which to amend that statute if it disagrees with this court's interpretation of the definition of materiality as requiring that a fact be at issue. The fact that the legislature has not seen fit in those 40 years to amend that statute if it disagrees with it suggests that the legislature approves of this court's interpretation of the statute as requiring that in order to be material, a fact must be at issue.
If it's not at issue, why are we putting on any evidence about it?
I agree. I don't know why we would, and certainly I would argue that only relevant evidence is admissible, so if it's not material.
But we do allow that, like on photographs, on gruesome photographs. The argument's always, hey, we're not disputing that there was a death here or the cause of death. And we've said, no, the prosecutor has to prove all the elements. And so that's an instance in which we've allowed the admission of evidence on a relevant fact that wasn't in dispute.
And I would respectfully argue that those cases are wrongly decided, but I would also point out that the rationale this court has used to justify those decisions is that there has to be testimony that it's helpful to the coroner in explaining to the jury something. So, but I would argue that those cases are wrongly decided and don't inform upon this case.
I've got a question. Looking at the statute, to give you an example, for instance, I was discussing the sexual misconduct definition under Section G, and one of the instances of sexual misconduct that it indicates are admissible is Section 3, exposing another to a life-threatening communicable disease, as described in subsection A1 of 2134-35. Can you imagine an instance where, although that's been described under Section 3 as sexual misconduct, that it might not be relevant and probative to a case, a sex offense under Article 34, 35, and 36? And maybe that's an example of what we're to be doing with the relevant and probative section of the statute, because it's not at issue in this case, as you're saying. Does that make sense?
I'm afraid I'm not quite following. I mean,
you're saying that relevance would require that it be at issue.
Yes.
And I'm saying that sexual misconduct is broadly defined here to include, for instance, Section 3, exposing another to a life-threatening communicable disease. Could you imagine that it might not be relevant and probative, even though that's an instance of sexual misconduct in a case like this?
Absolutely.
And that maybe that's what the trial court is supposed to be doing when they decide whether something is relevant and probative, even though it's defined as sexual misconduct under the statute. That's admissible.
I agree that wouldn't go to prove it. I think there's some confusion here because there's a difference between the evidence being at issue and it going to prove a fact that is at issue. So I guess I'm struggling with, yes, I think that you're absolutely right. That wouldn't prove a fact at issue in this case. I'm afraid I'm not.
Well, the statute says sexual misconduct, and as defined in the statute, is admissible, but then it also says it has to be relevant and probative, and I'm saying maybe what you are telling us, which is to an issue of fact in this case, gives meaning to that relevance and probative when you actually look at the definition of sexual misconduct and see that maybe all instances of sexual misconduct, as defined in the statute, are not relevant and probative to a sex offense under Article 34, 35, or 36.
I would agree. And I would point out that that's just another instance of the statute being poorly worded. It's rather redundant to say that it's both relevant and probative, as relevancy has a probative component. So honestly, I think the statute is so poorly worded that at best this court can guess as to what the legislature intended to do. No matter what we know of legislative history here. No matter what the legislature intended to do, if it didn't in fact do it, this court has said it won't darn the legislature's socks, and I think this court would be guessing at how to darn those socks in this case based on the language of the statute.
Shifting a little to the absence of mistake and whether that's an issue or not. It seems to me that this case is factually distinguishable from Prine in that the explanations that Prine offered really didn't explain that there was a mistake as to all of the types of activities that the victim had described. In contrast, in this case, the things that Mr. Spear said in talking to the investigator was a plausible, well, perhaps, but at least an explanation of a mistake that did explain exactly the type of conduct that the victim described. Given that, how do we as an appellate court make the judgment about what Mr. Spear really did intend to put into issue in the case?
I think that we can look to the fact that his attorney tried to suppress those statements. Therefore, his attorney did not intend for that excuse to inform his defense. If it were up to defense counsel and Mr. Spear, that evidence would have never come in, and he only addressed it because the state introduced it.
We don't know if that had happened if he would have had Mr. Spear take the stand. We have to make a lot of assumptions about what occurred or didn't occur, don't we?
I don't know that that's true. My understanding would be that if Mr. Spear had testified, he would be subject to cross-examination on any inconsistent prior statements, and that would have then come in had he said something like, I never touched her. Or so again, I think that I don't know that it's necessarily Mr. Spear's burden either. The bottom line is he tried to keep it out. The state chose to bring it in, and this court has said that the state cannot open the door to that evidence under 6455.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honors.
Thank you both for your arguments this morning. Court will take this matter under advisement.